so I will confine myself to the first set of questions. Now, first of all, yes, as you have noticed, under Article 43, where we refer to additional measures for the police to take in order to investigate into cases of offenses under this law, and by the way, as the Secretary for Justice has emphasized, this law prohibits very, very serious offenses. And as the Secretary for Security has explained, because of the severity of the offenses, they attract very heavy penalties. So this is the starting position of our discussion on the individual articles in this piece of ordinance. Yes, under Article 43, there is a power given to the Chief Executive to authorize interception of communication and surveillance by the Hong Kong police force. Yes, this is a very important power given to the executive. But as I said, this is because we are dealing with very serious offenses. And the chief executive, as I repeatedly said, he or she has accountability and responsibility to the Hong Kong Special Administrative Region and also to the Central People's Government. And we have been entrusted with the responsibility to implement a piece of law which safeguards not only Hong Kong people's interests, but the 1.4 billion mainland Chinese interest. So to have this power is very important and effective for us to ensure that we could discharge our function. I do not see how this executive power of the chief executive undermines the independence of the judiciary. They are entirely two separate matters. The judiciary will continue to adjudicate and conduct trials in accordance with the very important legal principles, including the independence of the judiciary, which we all embraced and put a lot of significance to. You also mentioned about human rights. Yes, this piece of law has said at the very beginning that we will safeguard human rights as provided for under the Basic Law and the two international covenants on human rights. But if you go through the two international covenants, for example, the ICCPR, it does clearly specify that some of the rights to be exercised by the individuals could be restrained or regulated by law if it is for the purpose of protection of national security. You also mentioned about conflict of interest. I don't see what sort of conflict of interest I will have in protecting national security in Hong Kong and for the country. My only duty and commitment as a chief executive is to serve the country and serve the people of Hong Kong. Now, finally, about the relationship between this piece of national security law and Basic Law 23. Yes, we have been deploying this explanation that somebody said we have been waiting for 23 years that Hong Kong SAR still could not enact local legislation to prohibit the 7 types of offenses that will undermine national security under Article 23. So this is a time for some resolute action. But Article 23 will continue to be effective. The government of the day will still have to enact local legislation on Basic Law Article 23, and this is clearly stated in Article 7. In Article 7 in this piece of national security legislation, and also in the decision passed by the National People's Congress on the 28th of May. So I wouldn't say that it is entirely because there isn't a Basic Law 23 that there is now this national security law, and one should not jump to the conclusion that if we have Basic Law 23, then we don't need this law. We have included, I think, an explanation in this booklet that even if Article 23 were to be enacted in a future date, the national security law now passed by the NPCSC, together with the local legislation passed by the Hong Kong Legislative Council, will together form the complete regime for protecting national security in Hong Kong. Secretary for Justice.
Let me supplement the Chief Executive in regard to your question about executive authorization in relation to interception of communications. First of all, many countries around the world, including Western countries, they have executive authorizations to intercept communications in relation to protection of national security. This is not new. They are doing it. So we now, because we have this new law, we have to discharge this function and duty. So it is necessary that we have a regime to take care of this matter. Obviously, different countries will have different ways to ensure sufficient safeguards are given. This is what we will be doing. What the law does say is, first of all, this has to be prescribed by law. Second thing is there should be sufficient safeguards. We will be looking at this method of executive authorization to satisfy those requirements. The second thing is we have to appreciate that in relation to national security matters, the targets that we are dealing with are likely to be of a state-level opponent. Their abilities, their methods, and their experience in this regard is something that we must take good care of in order to ensure that we can sufficiently discharge our duty. In regard to your other question about arrests having been made by the police, when the law is promulgated, it becomes effective law in Hong Kong. When it becomes effective law in Hong Kong, everybody has to abide by it. That is always the laws of Hong Kong. That is what the basic law says, and I think that should be our common sense and common knowledge. We will do education, but something that has been so outrageously broken the Hong Kong law, then the police has a duty to take action. We have established this new department to deal with this piece of new legislation. The police will handle it in accordance with the law. In regard to the detention, there is no provision in this national security law to change the procedure or law regarding detention. So we'll handle it in the way as it is stated in the present law.
Thank you. Shall I answer the question very quickly, please? Now, the fact that I'm on the National Security Commission, if we'll call that at the moment, would not in any way interfere with my discharge of the role as the head of the Department of Justice under Basic Law Article 63. What is important when one is to understand the independence of prosecutorial decisions is that Article 63 explicitly say that the Department of Justice is to control the prosecutorial decisions, conduct of the matters, etc., free from any interference. And therefore, anyone who attempts to, quote unquote, interfere or say specifically, forget about the evidence and just proceed to prosecute, of course, that would not be listened to. Any decisions that the Department of Justice is going to make in relation to prosecutorial decision will, as always, be based on fact and evidence. And the fact and evidence is something that will be provided to us through the law enforcement agencies, in particular in here, the special branch set up under the police force. And that will allow us to make the decisions independently, free from any interference. You've also mentioned in your questions about the situation regarding effectively the triggering or the carve-out part of the legislation which is within the jurisdiction of the central authorities. Insofar as that is concerned, that of course is already carved out and therefore no longer something that is within the jurisdiction of Hong Kong, and therefore how that is to be dealt with will be something that will not be within the purview that we will be able to interfere in that sense. All right.
Take one more English question.